Silence is your shield. Speech is your enemy. California sex crime survival.
Am I under investigation? If you are under investigation for a sex crime, it is quite likely you'll be the last to know. The majority of people will not know they are being investigated until the investigation is nearing completion. Contacting you for the police interview is typically the last step. So it is critical that you have skilled representation on your side. You will notice a reoccurring theme in this series. Retain the services of an attorney as soon as possible to work on the best defense possible. I'm Darryl Stallworth, and this is part 2 in our series regarding sex crimes in California. What do you do when the police come knocking? If the police show up to ask you questions, do not feel obligated to speak with them. You have the right to remain silent. If they are going to arrest you, they will do so whether you make a statement or not. Do not help them by giving a statement that can easily be misinterpreted. Under the stressful situation and at the hands of a skilled interviewer, your statements could be perceived as deceptive or false. It is important for you to remain calm, refrain from answering questions, and ask for an attorney. Many people wonder, if I ask for an attorney, do I look guilty? And the answer is no. Requesting an attorney during an investigation does not make you look guilty, it makes you look smart. It is the most important thing you can do. When you hire an attorney, the police are aware that you understand the gravity of the situation and are taking a proactive approach to protect your constitutional rights and freedom. A phone call from an attorney puts the officer on notice that you have an advocate. In the Bay Area, I know many of the investigating officers from my prior work as a prosecutor. There is mutual and professional respect, which often results in a courtesy phone call before an arrest is made. When I work with a client, my advocacy starts with a phone call to the investigatory agency. My next call is to the district attorney's office requesting a meeting or conversation with the charging prosecutor. Sometimes I'm able to provide the prosecutor with evidence from my own investigation in an effort to prevent my client from being charged. If I'm successful, it saves my client the trauma of an arrest and charge of a sex crime. If you are under investigation, first and foremost, stay calm. It's likely that your head will be spinning. However, the following actions can help make it easier for you to navigate through the criminal justice system. 1. Retain an attorney or request one immediately. Be sure to find an attorney with expertise, knowledge, and trial experience with sex crimes. 2. Do not speak to anyone about the case, including your family. It'll be difficult, but it's important that you only speak to your attorney about your case to avoid miscommunication, misinterpretation, and/or inconsistencies. I advise all of my clients that they're only allowed to speak with me about their case. In such a high-stress situation, it's natural to want to talk to friends, family about events in question and/or the accuser, but it's critical to only discuss the case with your attorney. Number 3, do not post about the case on social media. In fact, you can just suspend all your social media accounts. Avoid social media altogether. That means no posting, commenting, or conversing with friends. If you think that it's private, it's not. All of your information can be retrieved by the police. I've seen officers assume a false social media profile, gain access to your social media, and start a conversation. This makes it extremely challenging to retroactively defend any statements, photos, or videos posted to your social media. Anything that you've posted on social media could be used as evidence against you. Have you ever posted an inappropriate joke, a compromising picture of yourself, or other material that could be interpreted negatively? Even something as innocent as a picture of your kids, niece, nephew, a kid's soccer game, or school play can be reframed out of context against you. Further, social media is not the forum to state your side of events or emote how upset you are about the charges. Avoid the temptation. Don't look at it. Don't comment on any threads. Just shut it down. 4. Do not speak to the police. Your only statement to the police should be lawyer. The most damaging mistake you can make is talking to the police. I know this seems counterintuitive, but this is the time to stay silent. When the police call you or show up at your door, it's natural to want to explain yourself, to give your account of events. The officers know that you're scared and nervous and likely to say something to defend yourself. They're counting on it. Often, they will find a way to make you feel comfortable and lull you into saying something that may incriminate you. If you're being questioned about an event and you don't know what the other person knows about the event, you should not attempt to describe it to them. Bottom line, don't talk to anyone about anything, particularly when they have more knowledge about the case than you do. Remember, the police have already spoken to witnesses, looked at videos, and or completed a DNA analysis before questioning you. Anything you say, even if it's true, can be perceived as deceptive, and innocent, inaccurate recollection can be construed as untruthful. Number 5, don't contact or answer phone calls from the accuser. Do not attempt to contact the accuser. Period. Nothing positive can come from direct confrontation with your accuser. Further, you could be additionally accused of harassment. Never accept a phone call from the accuser. This call is very likely to be a pretext call. This is where the accuser, with the coaching of a police officer, calls you to solicit an admission. The conversations tend to go a little something like this.
Accuser, you know what you did was wrong. Why did you do that to me? You knew I was drunk/passed out. Yeah, I'm sorry about that.
Translation, you just made an admission of guilt. This will most certainly be used against you in any proceedings going forward. Unfortunately, in many circumstances, the accused thinks they are helping an emotionally distraught accuser with a generally comforting statement, when in reality, they are making a statement that could be interpreted as an admission. The investigation can ultimately lead to an arrest. So, to put it plainly, you shouldn't make it easy for someone to build a case against you. Taking a few proactive steps can help protect your rights and defense. Let's talk about what happens once an arrest takes place. There are a number of ways you can be arrested. Someone can report to the police that you have committed a crime. The police arrive, and if you are present, you can be arrested on the spot. Most often, a crime is reported, investigated, and a warrant for your arrest is issued. Armed with an arrest warrant, a police officer can arrest you on site. Yes, that means you can be arrested at your job, your school, your home, or any social event you might be attending. If you are represented by an attorney during the investigation process, sometimes the police, with assistance from your attorney, will allow you to self-surrender so you can coordinate when you actually turn yourself in, which can be a more ideal scenario than the surprise of being picked up out of the blue. Most arrests follow a very basic protocol. You'll be transported to the local police department, processed, fingerprinted, and logged into Criminal Division Databank. Mirandized, read an admonition that informs you that you have the right to remain silent and the right to have a lawyer. If you waive your right to remain silent and have an attorney, you will then be questioned. You are allowed a phone call, but when you get to make that call varies. In the stressful situation of arrest, there are 3 crucial items to remember. 1, you have the right to remain silent. Remaining silent means just that. Do not answer any questions. Investigators will do their best to get you talking. These individuals are pros and have conducted hundreds of interviews, all designed to get you to make a statement. Once you start answering questions, your defense becomes 100 times more challenging. Here's what you should do. Remain calm. Put your head down and say one word, lawyer. 2, you have the right to an attorney. Regardless of the charge, you have the right to an attorney. If you cannot afford one, an attorney will be provided. You do not need to have a private attorney to exercise your right to request one from the moment you are arrested. 3, you have the right to reasonable bail. Depending on the type of sex crime charge, bail may be set from $50,000 to upwards of $1 million. Most bail bond companies will charge you 10% of the bail and require collateral for the balance. If you are represented by an attorney, they will sometimes only require 6 to 8% of the bail amount up front. Your attorney will also work to get your bail reduced. Now, if you have not secured an attorney at this point, what are you waiting on? It is possible for someone accused of a crime to represent themselves, but why would you? That's like performing your own surgery without the skill set or license to do it. I've told you a few do's and don'ts so far, and on the subject of self-representation for a sex crime, I'm sure you can guess which category this falls into. This is a huge don't. Representing yourself against a sex crime is the worst decision you can ever make. An attorney is critical to ensure your rights and ultimately your freedom are protected. If you cannot afford a private attorney, the public defender will assist you. Public defenders are real attorneys, even though they are free. It is true that with the large caseloads that most public defenders carry, they can be less accessible than a private attorney. Additionally, when assigned a public defender, you do not have the ability to choose your attorney, but having an attorney you did not choose but did not have to pay for is better than having no attorney at all. Whenever possible, I highly recommend retaining the services of an experienced private attorney. Why? A good experienced private attorney will be more available to you. I know that my clients are in a highly stressful, traumatic time that doesn't regulate itself to a 9 to 5 schedule Monday through Friday. I've spent many late nights and weekends counseling clients throughout their case. While I cannot speak about the methodology of all private attorneys, when I am retained by a new client, I often start by gathering as much case information as possible, which can include obtaining the police report, speaking to the prosecutor, coordinating legal experts, conducting my own investigation, including a physical examination of the alleged crime scene, researching the accuser's background. This dedication to comprehensive case preparation, combined with our commitment to being available around the clock, often working late nights and weekends, allows us to provide our clients with the diligent, personalized service they need during such a critical time. A few years back, I had a client accused of sexual assault where the accuser claimed that she suffered from self-image issues as a result of the accused's conduct. She stated that she could no longer go outside and felt everyone was looking at her. Additionally, she was now uncomfortable around men and her relationships with men were destroyed. An investigation into her background revealed social media images and video postings that suggested quite the opposite. Further, as part of the client's defense, we conducted a physical examination of the alleged crime scene where we obtained our own photo documentation, created maps, and the accuser's cell phone records were pulled. We also researched the accuser's background, history, prior reports, and psychiatric records. The same thoroughness was applied to all potential witnesses, including police officers. As a result, we were able to discredit the foundation of the case and ultimately have the felony dismissed. In another case, the investigation was vital to a proactive defense. A witness testified that the accuser was an angel, didn't drink, and had never been in trouble before. My investigation uncovered a video of the witness and accuser consuming alcohol together. The witness lost all credibility with the jury. This case also resulted in a felony dismissal. Diligently preparing and effectively leveraging investigation tactics are our essential pillars in constructing a robust defense in cases involving sex crimes. It can lead to case dismissals or a reasonable resolution during the plea bargaining process. A plea bargain, often referred to as a deal, is any agreement in a criminal case between the prosecutors and accused, whereby the accused agrees to plead guilty or no contest to a particular charge in return for some concession from the prosecutor. This may mean that the accused will plead guilty to a less serious charge or to one of several charges in return for the dismissal of the other charges. While a plea bargain is tempting in the face of a long, uncertain trial, accepting a deal is not always best. An experienced and knowledgeable defense attorney is imperative to assist the accused with this decision. Typically, a plea offer will be made by the prosecutor prior to the preliminary hearing. However, it can be beneficial to conduct the preliminary hearing before accepting an offer. A preliminary hearing is commonly referred to as a probable cause hearing. It is a judicial hearing where the prosecutor is required to introduce enough evidence to convince the judge that it is more likely than not that the accused has committed the crime charged. This standard of review is vastly different than the reasonable doubt standard applied at trial. It's probable cause. Most prosecutors only introduce the minimum amount of evidence required in order to prevail at a preliminary hearing. In cases involving a sex crime, a prosecutor will almost always have the accuser testify. The accused rarely introduces any evidence at a preliminary hearing. It is merely an opportunity to evaluate and challenge the credibility of the accuser. I defended a case where 5 men were accused of kidnapping 4 young girls and subjecting them to various sex crimes. All 4 of the accusers testified during the preliminary hearing, where I was able to challenge all of their conflicting and embellished descriptions of events. After being caught in a web of lies, the accusers refused to answer any more of my questions. At the end of the preliminary hearing, the 5 men were released from custody and offered plea deals that did not require incarceration or sex offender registration. Plea offers can be negotiated. The facts of your case, the accuser's credibility, the strength of the witnesses, and the reputation of your legal representation can all affect your plea arrangement. In the negotiating process, it is not uncommon for offers to go back and forth a few times before ending up with an agreement that is acceptable to both sides. Deciding to go to trial is a serious and thoughtful decision made with my client after I have completed my review of the case, conducted all of my investigation, and carefully weighed the likelihood of prevailing at trial. This decision is likely to be the most important decision my client has ever made. Consequently, it is imperative that I spend as much time as necessary meeting with my client and their family, discussing every concern they may have. It is deeply concerning when I hear the decision to go to trial is made, where an attorney has spent very little time reviewing the case with the client. My clients have the benefit of knowing that I have carefully reviewed all the strengths and weaknesses of their case, and that we have thoroughly discussed the decision to go to trial or accept a plea agreement. Oftentimes, we will discuss this decision for weeks, sometimes months before a decision is made. Now, if we decide to go to trial, it's important to know that trial preparation is a marathon, not a sprint. Forget everything you've seen on TV where the investigation, arrest, and trial are concluded in an hour episode. A trial is a process that requires a methodical approach. Many of my clients get anxious when the wheels of justice turn slowly. Moving slowly is often required to grind out what we want or something close to it. My advice is to be patient with the process. Before a trial starts, the prosecutor and the defense attorney will submit a motion requesting that the court make a decision on certain issues before the trial begins. The motions typically address jury selection, courtroom protocol, physical evidence, and testimony. When a jury trial is ready to start, the court will request a panel of prospective jurors. The judge commonly begins the selection process by identifying those jurors who are unable to serve due to a legally recognized hardship. The judge and the lawyers then select the jury by a process known as voir dire, which is Latin for to speak the truth. In voir dire, the judge and the attorneys ask potential jurors questions to determine if they can be a fair and impartial juror. The prosecutor has the burden of proof and thus is required to convince all 12 jurors that the accused is guilty beyond a reasonable doubt of the crimes charged. The prosecutor will introduce the evidence through the testimony of officers, doctors, experts, and the accused. The defense attorney challenges the prosecutor's evidence through cross-examination. At the conclusion of the prosecutor's case, the defense may but is not required to present a case. After both sides have rested, the prosecutor delivers a closing argument followed by the defense attorney's closing argument, which is then followed by the prosecutor's rebuttal argument. The judge will then read jury instructions to the jury. The jury can deliberate for as long as they like until they reach a verdict or conclude that they are unable to reach a unanimous decision, resulting in a mistrial. If convicted, meaning the jury found you guilty of one, some, or all the offenses charged, the matter will proceed to the sentencing phase. Receiving a more severe penalty than what the prosecutor offered before trial is a major risk of going to trial. While no one will go on the record and state that they are going to punish you more severely because you exercised your constitutional right and challenged the prosecutor's case by going to trial, it is often a reality. If convicted of all charges, then it is likely going to be harsher. If the prosecutor pled and proved aggravating factors, they will likely ask for the most incarceration time they can get, while your attorney will work toward convincing the judge to impose a lower sentence if convicted. Besides incarceration, deportation, and other collateral consequences, a result of being convicted of a sex crime is the requirement to register as a sex offender. The California Sex Offender Registry is designed to provide information to law enforcement and the general public about sex offenders. Most misdemeanor sex crimes do not require sex offender registration. Felony cases almost always require registration. Under Penal Code 290, California law requires that people convicted of certain crimes must register as a sex offender. A convicted sex offender must register with the local law enforcement agency annually within 5 days of his/her birthday and within 5 days upon moving residences. If you are in college, you must register with the campus police. If your offense involved a minor, you may not live near any school or work for any place that comes into contact with kids or young adults. You will also have to notify your employer. In your county or city, there is a list that your name will appear on. Anyone who wants to find out about you can go to the list. Sex offender registration eliminates about 90% of the types of jobs you can get. Recently, laws have been passed in California that have modified the lifetime requirement for registration as a sex offender. For example, sex crimes that are considered non-serious may only require a 10-year registration period. Tier 2 offenses require 20 years of registration, and Tier 3 offenses are lifetime requirements. Now, if you beat your case at trial, there are still the lasting implications of having been accused. If you were accused of a sex crime and ultimately not convicted, you could still have trouble getting work, restoring your reputation, or overcoming the traumas that a sex offense accusation can bring. I had a client who got exonerated, but because of all the publicity of the case, it took a long time for people to overcome it. Although you've been exonerated or the case has been dismissed, most search engines will find a record showing that you've been arrested for a sex crime. Just because you're arrested doesn't mean that you did it, particularly since you've been exonerated. However, if an employer has to choose between you and 5 other candidates who don't have a publicly searchable arrest for a sex crime, it is unlikely that they are going to hire you over the candidate with less baggage. There are laws that prohibit employers from using arrests that did not result in convictions. But like many things, the system remains broken, and those wrongfully accused still suffer unfair stigmas that linger for years. If you or someone you know is facing the daunting challenge of overcoming a sex crime accusation, it's crucial to have the right support on your side. At our law firm, we are dedicated to helping you navigate this difficult time and fight for your rights. Our experienced team understands the complexities of these cases and is committed to working tirelessly to clear your name and restore your reputation. Don't let an accusation define your future. Reach out to us today for a consultation. Together, we can develop a strong defense and help you take the first steps toward getting your life back on track. Contact us now to begin your journey towards justice and peace of mind.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.